Everything that is explained in this video is summarized from CoinMarketCap. Now take a look at this. US SESC files entry for final judgment against Ripple. A motion for remedies and entry of final judgment has been submitted by the Securities and Exchange Commission in the ongoing legal struggle that Ripple Labs has been engaged in for a considerable amount of time. Specifically, the commission is requesting that the court grant permanent injunctions, disgorgement, and prejudgment interest by the provisions specified in the proposed final judgment. On the other hand, the SEC had also discussed the civil fines that were involved in the case. Attempts by the SEC to finalize the pact, according to the documents that were submitted to the court. The commission argues that the move is supported by a memorandum of law, declarations of Peter B. Moores and Andrea Fox, and that it also includes additional exhibits. When it comes to Ripple Labs, it is essential to take note of the fact that the SEC has requested a definitive judgment. In particular, Section 5 is the focus of the commission's efforts to obtain permanent injunctions against any future violations of the Securities Act of 1963. Nevertheless, the issue revolves around Ripple's purported operation of unregistered offerings of XRP in the context of institutional sales. In the document, it was said that these measures are essential to prevent the defendants from engaging in unlawful activities in the future. It is now time for the second point, in which the commission is requesting some kind of remedy. On the other hand, it included a prejudgment interest that was equal to $198,150,940 at the time. These amounts are the profits that Ripple accrued as a result of its violations of regulations governing securities operations. A civil penalty with a total amount of $876,308,712 is being proposed by the Securities and Exchange Commission. The imposition of this penalty will function as a mandatory measure. It is anticipated that this will serve as a deterrent for Ripple and other entities to refrain from committing infractions of a similar nature in the future. The motion asks, what does it say? The action draws attention to Ripple's long course of violations of securities regulations, which totaled $1 billion. These violations were largely committed by Ripple through its unregistered offer and sale of XRP, institutional buyers, and other counterparties. Because of these infractions, hefty penalties and the return of earnings are required to ensure that illegal behavior is stopped and to discourage future behavior. Furthermore, the SEC emphasizes Ripple's unwillingness to accept responsibility for its violations, as indicated by its mischaracterization of the court order as a total victory and its lack of transparency surrounding its business activities. Both of these behaviors are examples of Ripple's failure to accept responsibility for its crimes. Even though Ripple was given legal counsel about the sale of XRP for cash and the promotion of it as an investment, the company chose to disregard this guidance, which indicates that they intended to circumvent the law. The Securities and Exchange Commission contends that the only way to get Ripple to change its behavior and comply with securities rules is to impose sanctions and restore any wrongfully obtained earnings. The relief that has been asked is intended to prevent other violations, to deprive Ripple of its unlawful advantages, and to solve the problem of the damage that has been done to the markets. Fred Rispoli, a legal expert, provides an explanation for the ongoing disagreement and legal dispute that exists between Surge Labs and the United States Securities and Exchange Commission. His analysis sheds light on potential significant developments in the circumstance, illuminating the implications that it has for Surge and the cryptocurrency industry as a whole. Inquiring into the motion of the CC, the Securities and Exchange Commission, has submitted a motion that suggests that Ripple should be fined approximately $2 billion. Nevertheless, we will likely acquire additional information from new documents. There is no doubt that the Securities and Exchange Commission's move has significant market repercussions for Ripple and the whole cryptocurrency industry. Based on her speculations, Rispoli proposes two possible outcomes: either a peaceful settlement immediately following the verdict of the court, or a grueling legal battle with restraining orders. Rispoli's analysis on the situation, Fred Rispoli, a well-known advocate for XRP, contends that the case's nuances are important in determining the gravity of the claims that the SEC has made against Ripple. Nevertheless, no Ripple or XRP fan will ever be able to know the outcome of the litigation, and the SEC is calling for actual damages to be imposed on retail investors, even though Ripple is unable to provide evidence to support this claim. During the process of dissecting a significant portion of the motion, special emphasis is being paid to the selling of discounted XRP institutional purchasers. Without a shadow of a doubt, this has already triggered a variety of implications for the market, particularly for retail investors and the rest of the ecosystem. These consequences will undoubtedly occur in the future. However, concerns have been raised about Ripple's sales of XRP after the case has been resolved. All of these things need to be investigated in even greater depth, including how the company situated in San Francisco generates revenue and the kind of contracts it enters into with institutional purchasers. The analysis conducted by Fred Rispoli provides significant knowledge of the potential effects that the SEC action could have on Surge, as well as the cryptocurrency market. As the legal battle continues to unfold, Rispoli's perspectives shed insight into the complexities of the situation and the outcomes that could be feasible there. In his most recent views on X, Bill Morgan brought out the possibility that Ripple could be subject to legal problems as a result of the ongoing legal struggle with the United States Securities and Exchange Commission. Despite the fact that this pundit does not provide thorough information and has a tendency to exaggerate, his remark concerning the company's institutional sales methods is worth considering in the context of Ripple's project and the impact it has on prices and other aspects. A summary made by Bill Morgan chart about remedies was submitted by the SEC 2 days ago, and today was the day that the public disclosure was officially presented to the public. As a result, we have learned from the historical interview that the SEC side has requested, in addition to everything else, a sum of $7 billion as a consequence of the damages and the fine that was imposed. Following the release of this statement, Bill Morgan expressed his worries on Twitter on the charges made by the SEC regarding Ripple's institutional operations. Additionally, Morgan drew attention to the SEC's assertion that Ripple caused injury to other institutional investors by offering substantial discounts. A total of $480 million in damages were incurred by institutions as a result of such damage, according to the SEC. According to the Securities and Exchange Commission, the market price of XRP is being reduced as a result of sales that are being made at discounts to certain institutional investors. All these assertions that are included in the SEC brief, as well as the information that supports those assertions, in which I need to find the time to examine in greater detail, must be at. Morgan asserts that such a statement gives the impression that all other investors who did not receive the discounts are now eligible to be plaintiffs in the class action litigation. In this context, numerous thematic cases can be made against Ripple by institutions claiming that the failure to disclose discounts throughout the purchasing process caused them to suffer injury. According to the author for the causality to file the thematic cases, it would be necessary to have a strong argument in favor of timing. According to Morgan, the fact that the Securities and Exchange Commission, SEC, has classified Ripple sales to institutions as investment contracts suggests that the disclosure of discounts ought to have been given if the sales had been registered. This particular facet adds even another layer of complexity to the legal proceedings and highlights the significance of transparency in the transactions involving cryptocurrencies.